Hello, everybody, and welcome to Law Bite number 338, dated January 12, 2022. I'm Walter, your mobile historian and blue-collar scholar. This Law Bite is entitled The Voting Rights Act of 1965, Sections 2, 201, 202, 203, 208, and 11. Before I begin, however, I'd like to formally invite you to subscribe to my YouTube channel, Juarez Lee Shelton, M.A. And in addition to that, please also click on that little notification bell immediately to the right of the subscribe button. In doing so, you will receive notifications when I post new, exciting, and enlightening videos in history, law, political science, theology, and philosophy. Thank you so much in advance. Again, this video is entitled The Voting Rights Act of 1965, Sections 2, 201, 202, 203, 208, and 11. The Voting Rights Act of 1965, for those who are unaware, is a monumental federal civil rights law prohibiting discrimination in voting based on race, color, and language minority, and thus facilitating participation in federal, state, and local elections. Additionally, it allows the federal government to oversee and review state and local election laws and procedures when claims of discriminatory practices have been successfully pursued in court. Contrary to misguided beliefs, the Voting Rights Act does not confer the right to vote upon anyone, but instead it provides several mechanisms for enforcing and protecting that right for everyone, regardless of race, color, or language minority group. As the Voting Rights Act is a very lengthy statute with numerous amendments through time, this lecture will give a brief overview and analysis specifically of Sections 2, 201, 202, 203, 208, and 11. So just a little bit of background first. The Voting Rights Act was passed by the 89th Congress on August the 5th and signed into law by President Lyndon B. Johnson on August the 6th, 1965. The Voting Rights Act as such came into being in an era when voter discrimination in America was blatant and rampant. Prior attempts to enforce the 15th Amendment to the Constitution in the past had been largely unsuccessful. But the Voting Rights Act would prove to be the strong medicine that was needed to wipe out the vast and unrepentant voter discrimination that existed in the United States of America at the time of its passage. For reference purposes, the event known as Bloody Sunday in Selma, Alabama on March the 7th, 1965, was the heart-wrenching event that provided President Johnson and the Congress with the political capital to seek this law so soon after the passage of the Civil Rights Act of 1964. The late Congressman John Lewis, who represented Georgia's 5th Congressional District from 1987 to 2020, was a participant in that most historic event. He was living history indeed. So, the Voting Rights Act of 1965, otherwise known as the VRA, has several specific sections that allow for particular types of voting rights enforcement. Specifically, sections 2, 203, 202, 201, 208, 3A, 3C, 4A, 4B, 5, 6, 8, and 11. Again, this video, as I explained to you, the Voting Rights Act is a very long statute with a lot of amendments. So this video right here will only cover sections 2, 201, 202, 203, 208, and 11. Other videos contain information on the other sections. So beginning with Section 2. This is arguably the most potent arm of the Voting Rights Act since the Supreme Court's decision in Shelby County versus Holder in 2013, which I cover in a separate video. That decision declared the preclearance coverage formula in Section 4B of the Voting Rights Act to be unconstitutional, leaving Section 5, which required U.S. Attorney General or U.S. District Court approval of voting laws, inoperable until a new formula is enacted by the Congress to fill in for the section in 4B that was ruled unconstitutional. Okay? So Section 2 is a permanent nationwide prohibition on discrimination in voting practices and procedures, including redistricting plans and at-large election systems and voter registration procedures, which discriminate on the basis of race, color, or language minority group. This section therefore forbids election-related practices that have a discriminatory intent, as well as those that are shown to have a discriminatory result. The scope of Section 2's protective power was initially vague until the Supreme Court's adverse decision in the case of Mobile versus Bolden in 1980. That case held that a discriminatory intent had to be present to prevail under a Section 2 claim. As a result of amendments added in 1982 to counter the Mobile decision, Section 2 now contains what's known as a results test, prohibiting any law with a discriminatory effect or purpose, regardless of whether it has a discriminatory intent or whether it was maintained for a discriminatory purpose. Thus, Section 2 provides judicial relief for voters who believe that their voting rights have been denied or limited based on race, color, or language minority group. Courts have often used the information from the Senate Judiciary Committee reports from the 1982 amendments to decide whether jurisdictional laws violate the general prohibitions of the Voting Rights Act. They are as follows: the history of official discrimination in the jurisdiction that affects the right to vote. Next, the degree to which voting in the jurisdiction is racially polarized. Next, the extent of the jurisdiction's use of majority vote requirements, unusually large electoral districts, prohibitions on bullet voting, and other devices that tend to enhance the opportunity for voting discrimination. Next, whether minority candidates are denied access to the jurisdiction's candidate slating process, if any. Next, the extent to which the jurisdiction's minorities are discriminated against in socioeconomic areas, such as education, employment, and health. Next, whether overt or subtle racial appeals in campaigns exist. Next, the extent to which minority candidates have won elections. Next, the degree that elected officials are unresponsive to the concerns of the minority group. And next, whether the policy justification for the challenged law is tenuous. So the aforementioned list is not exhaustive, all right? And courts are certainly allowed to take other factors into consideration when making determinations on discriminatory practices. Section 2 litigation over the years has resulted in two types of litigation: vote denial and vote delusion. To elaborate, vote denial occurs when someone is denied the ability to cast a ballot or have that vote properly counted. Vote dilution occurs when the force or effectiveness of a vote is significantly reduced. Needless to say, most litigation under Section 2 has been due to vote dilution by way of proposed legislative redistricting plans at the state and local levels. These suits have typically been based on claims that through these redistricting plans, minority groups have been unable to select preferred candidates in elections. In the Supreme Court's Thornburg versus Gingles decision in 1986, a specific framework was given for how to pursue vote dilution through submergence claims. Plaintiffs are required to show the existence of these three factors. Number one, the racial or language minority group is sufficiently numerous and compact to form a majority in a single-member district. Number two, the minority group is politically cohesive, meaning its members tend to vote similarly. And number three, the majority votes sufficiently as a bloc to enable it usually to defeat the minority's preferred candidate. So assuming that those three conditions have been met, then the plaintiffs in these cases must additionally show, based on other evidence in the case, as well as based on the 1982 Senate factors that we just reviewed, that under the totality of the circumstances, that the plan in question reduces the ability of the said minority to elect candidates of its choice. And that's not always an easy wall to scale. Section 2 has been ruled not to prohibit felony disenfranchisement in the case of Richardson versus Ramirez in 1974, as the practice is permissible under the language of the 14th Amendment. The case of Shaw versus Reno in 1993 held that the use of race in drawing districting lines may violate the 14th Amendment's Equal Protection Clause. This runs in stark contrast to two decisions in 2017, Bethune-Hill versus Virginia State Board of Elections and Cooper versus Harris, which have allowed limited justification for district lines to be drawn based on race in order to reduce a jurisdiction's potential Section 2 liability. All right. In Johnson versus DeGrande in 1994, the Supreme Court held that the section does not require states to maximize the number of districts in which a minority group can elect preferred candidates. Moving forward to 2009, in the case of Bartlett versus Strickland, the court held that in order to satisfy the first requirement in Gingles from 1986, the minority group must show that it could constitute a majority in a theoretical district, not just that it could serve as a swing vote in a competitive district. So that takes us to sections 201, 202, 203, and 208. Section 201 forbids any individual from complying with a test or device in order to be able to register to vote or cast a vote in an election. Test or device is defined as literacy tests, education or knowledge tests, proof of good moral character, or having someone vouch for them when they attempt to vote. Section 202 serves to prohibit any durational residency requirements in excess of 30 days before being allowed to vote in a presidential election. Section 203 provides protection for language minority voters. Specifically, it reads, whenever any state or political subdivision covered by the section provides registration or voting notices, forms, instructions, assistance, or other materials or information relating to the electoral process, including ballots, it shall provide them in the language of the applicable minority group as well as the English language. Section 208 disallows jurisdictions from prohibiting a non-English speaking or disabled person from bringing an individual with them into the polling booth, except if the individual is from their employer or union. So that takes us to Section 11. There are also several prohibitions on specific forms of conduct located in Section 11 that inhibit the ability of an individual to cast a vote. Section 11A prohibits anyone acting under color of law for disallowing an otherwise qualified person to vote or refusing to count their ballot. 11B forbids any person intimidating, harassing, or coercing another person voting or who is attempting to vote. 11C forbids the submission of false registration to be able to vote in a federal election. And 11D provides that a person within the jurisdiction of an examiner who knowingly falsifies or conceals a material fact or makes false statements or representations or uses a document that contains false or fraudulent statements is subject to a fine of $10,000 imprisonment. Okay, a fine of $10,000, imprisonment for 5 years or both. Pardon me. Lastly, Section 11E disallows voting twice in a federal election. Okay? So, though Section 2 has been used throughout the years, the amount of Section 2 lawsuits has grown considerably since the Supreme Court's decision in Shelby County versus Holder in 2013, which we mentioned at the very beginning of the section on Section 2. As Shelby County versus Holder gutted Section 4B of the Voting Rights Act, it left Section 5 essentially inoperable. The jurisdictions that were previously covered by Section 4B all required Section 5 pre-clearance before changing any of their election laws. Okay? And now that that coverage is no longer there, they can change whatever they want without virtually any oversight unless it's challenged after the fact. The beauty of federal preclearance was the federal government, the Justice Department, or the U.S. District Court for the District of Columbia had to approve it before it could go into effect. All right, so that would get nipped in the bud from the get-go. It wasn't allowed to go into effect without the Justice Department's approval, all right, or the U.S. District Court for the District of Columbia's approval. With Section 2 litigation, you've got to challenge it after the fact. So the damage may well have, irreparably already been done, okay? So, like I said, before Shelby, these jurisdictions had to prove to the Justice Department or the U.S. District Court in D.C. that their voting laws would not adversely affect people of color. But with a Section 2 lawsuit, the burden is on the petitioner, all right, to prove that the challenge law does in fact discriminate against voters of color or a language minority. Needless to say, that is not always a walk in the park to accomplish, okay, in spite of a law clearly having an adverse impact on minority groups. Sections 4B and 5 requiring preclearance were the real heart and soul of the Voting Rights Act. And conservatives had been going after them for years until they finally accomplished their goal with Shelby County versus Holder. Because these sections were able to stop discriminatory changes before they could even take effect. With Section 2, like I said, typically the damage has to be done first. Okay, the law has gone into effect, and it can be demonstrated that this law has an adverse effect on the minority group here before a suit can be initiated to prove that the law is adverse to voters of color or to a language minority. So you see it's a big difference from Sections 4B and 5. All right. So in July of 2021, the U.S. Supreme Court again interpreted Section 2 and its applicability to state election practices. So here, in the case of Brnovich versus Democratic National Committee, 2021, the Supreme Court ruled 6-3 that the two Arizona state laws in question one law forbidding ballot harvesting, and the other law banning the counting of ballots cast at the wrong polling place, were not in violation of Section 2 of the Voting Rights Act. The court reasoned that the section here was not offended because there was no discriminatory intent by the state of Arizona here, or a disparate impact shown by the respondents. Okay, so the court did not find that the state of Arizona had a discriminatory intent in enacting these laws, nor did the respondents in the case show that the laws had the law's implementation and promulgation and effects had not shown a disparate impact, okay, on the respondents here. Okay, so in other words, the law was not shown to have a negative effect on them. So the court did not find it to violate Section 2 of the Voting Rights Act. All right. And that is the most recent time at this point, at the time of this recording, that the Supreme Court has ruled on Section 2 of the Voting Rights Act. One very important thing to remember here is that as the Voting Rights Act of 1965 is a federal statute, it is not a constitutional provision. Congress can easily amend the language of the Voting Rights Act to overrule a Supreme Court decision based on the plain language of the act. After all, it's a statutory decision, and when it comes to a statutory decision, Congress can simply amend the language of the statute to have the effect of overruling an adverse Supreme Court decision, as Congress did in 1982 when they added several amendments to Section 2 of the Voting Rights Act, effectively overruling the Supreme Court's decision in Mobile versus Bolden in 1980. Okay, so if Congress wishes to strengthen the force of Section 2, it can do that anytime it wants, and that could have the effect of overruling any Supreme Court decision that serves to weaken the force of the Voting Rights Act. All right. And with respect to Sections 4B and 5, Congress would have to adopt a new formula only because in Shelby County versus Holder, the court invoked the Constitution. Now, Congress can't do anything about that. However, if the court merely invokes the language of the statute, Congress can have the last word with that. But when the court invokes the Constitution and the court have the last word. All right? And at that point, only the Supreme Court itself can overrule that decision, or a constitutional amendment can overrule it as well. But Congress, through mere legislation, can't change the effects of that decision. All right? So that concludes this lecture on Section 2, as well as the other prohibitory sections of the Voting Rights Act contained in 201, 202, 203, 208, and Section 11. The purpose of this video is to provide you with an overview of specific sections of the Voting Rights Act of 1965, and is not to be construed as legal advice in any format. This is entirely educational in nature. I am not an attorney at law and therefore not authorized to give you legal advice, okay? Legal questions, please seek the advice of an attorney. If you are experiencing issues surrounding your voting registration, your voter registration, the active status of your registration or lack thereof, please contact your local board of elections, okay? And if you are experiencing any issues with respect to voting per se, all right, you've been denied the vote, or you are unable to register, or whatever your particular legal situation may be, if you feel your rights have been violated, you would be wise to perhaps contact the U.S. Justice Department and its Civil Rights Division, and they would certainly be able to tell you whether or not your specific rights have been violated under the Voting Rights Act of 1965, and may be able to help you pursue a case, okay, by way of the Voting Rights Act, if you perhaps have faced any of the legal situations mentioned in this lecture. Okay, so that concludes this brief monologue on the Voting Rights Act of 1965, focusing on sections 2, 201, 202, 203, 208, and 11. I thank you so much for listening. If you have any questions or controversies, please leave them down below, and I'll be happy to answer them. If you enjoyed this video, liked it, learned a little thing or two from it, please like the video. It would be graciously appreciated. And if you have not subscribed to my YouTube channel at this point, please do so now. It would be greatly appreciated. Juarez Lee Shelton, M.A. So I leave you with the timeless words of one of my teaching role models, Mr. George Feeney. Believe in yourself, dream, try, do good. And my own words, take care, stay safe, be blessed, and I'll talk to you at the next video. Peace.